Defense Counsel, the adversary system of the criminal trial. The adversary system of the criminal trial which we have adopted assume that the state using it investigative source and employ in a competent prosecutor. Competent prosecutor would prosecute the accused who in turns will employ or in equal competent defense counsel to the challenge of the evidence of the prosecution. Evidence of the prosecution full stop. Therefore, both the Constitution of India and the Code confirm on the accused person in a right to consult and to be legal defended by a partitioner legal partitioner of this choice full stop. The right to conceal would whoever remain empty if the accused due to this poverty or indigent condition has no mean to engage a counsel for this defense. The indigent accused obviously stand the risk of the potential of a fair trial when he does not have equal access to the legal service available to the opposite side full stop. To in extent the court has been attempted to find a solution to this problem. Full stop. It has been provided that where in a trial before the session court the accused is not a case is not represented by a plender and where it appear to the court that the accused has not sufficient mean to enage to plender enage a plender. The court shall assign a plender for this defense at the expense of the state. Further, the court has been empowered the state government to extend the application of the above provision to any class of trial. Any class of the trial before other state हो गया. It may also be noted that the Supreme Court has held that Article 21 of the Constitution implicitly required the state to make provision for the grant of free legal service to an accused who is unable to engage a lawyer on account of reasons such as poverty, indigence or a situation, a communist situation full stop. The only qualification would be that the offense charged against the accused is such that on conviction it would result in a sentence of imprisonment and is of such a nature that the circumstance of the case and need of the social justice required that he could be given in free legal representation full stop. This goes far beyond section 304. This goes far beyond section 304 of the code. At present there are cervical scheme in vogue which enable the indigent accused to get free legal aid. In this context, it may be pertinent to note that the provision of the Legal Service Authority Act 1987 enable the judiciary to provide the defense counsel, the adversary system of the criminal trial. The adversary system of the criminal trial which we have adopted assume that the state using in a investigative resource and employ in a competent prosecutor. Competent prosecutor would prosecute the accused, who in a turn will employ or equal competent defense counsel to challenge the evidence of the prosecution, challenge the represent to indigent accused, representation to indigent accused if the service provided are found wanting the trial may be vindicated. The court, Supreme Court, Supreme Court, the Constitution establishes the Supreme Court and define its jurisdiction and power. Define its jurisdiction and power. The court further make provision of the appeal to the Supreme Court. Provision of the appeal to the Supreme Court under the certain circumstance and also able the Supreme Court to transfer case and appeal in the interest of justice. Appeal of the interest of justice. Full stop. The Supreme Court also exercise appellate jurisdiction in criminal case. Jurisdiction in a criminal case under the provision of the Supreme Court. Enlargement of the criminal appellate jurisdiction. Enlargement of the Criminal Appellate Jurisdiction Act 1970. Appellate enlargement of the Criminal Appellate Jurisdiction Act 1970. Jurisdiction Act enlargement of the Criminal Appellate Jurisdiction Act 1970. High Court. The Constitution provide for the establishment of the High Court for each state and generally define the jurisdiction of such High Court. Jurisdiction of such High Court. Okay, jurisdiction of such High Court. Full stop. The High Court has got superintendent over all court throughout the concerned state. Full stop. The code also provide that the superintendence over the court of the judicial magistrate to be so exercised as to ensure in expeditious and proper disposal of case in such court. Full stop. The court given to the High Court. The court given to the High Court various power including these related to reference, appeal, provision and transfer of case. Full stop. It also recognize especially the inherent power of the High Court to prevent the abuse of the process of any court or to secure the end of the justice. Session Court. The state is to establish a session court. The state is to establish a session court for every session division. Session court. Okay. The state is to be establish a session court for every session division. Full stop. The court is to be presided over a judge appointed by the High Court. Full stop. The High Court may also be appoint additional session judge and assistant session judge to exercise the jurisdiction in session court. Full stop. In assistant session judge is subordinate to the session judge. Court of the judicial magistrate. In every district, the state government may, after consultation with the High Court, establish as many court of the judicial magistrate of the first class and of the second class it may consider necessary. The state government may also be after the Supreme Court, High Court or Session Court. Session court is to establish a session court for every session division. Every session division, full stop, the court is to be presiding over in a judicial appointment. Judicial appointment by the High Court. Judicial appointment by the High Court, full stop. The High Court may also appointed additional session judge and assistant session judge to exercise jurisdiction in session court. Jurisdiction in session court in full stop in assistant session judge is a subordinate to the session court. Subordinate to the session judge. Subordinate to the session judge. Court of the judicial magistrate. Court of the judicial magistrate in every district the state government may, after consultation with the High Court, establish as a mini court of the judicial magistrate of the first class and of the second class. It may consider necessary. The state government may also be after consultation with the High Court, establish for any local area one or more special court of the judicial magistrate of the first class of the second class to try any particular session or particular class of case, full stop. Where any such special court has been established, no other court of the magistrate in the local area shall have jurisdiction to trying any such case or class of case, full stop. The presiding officer of such court, including special court, shall be appointed by the High Court. The High Court may also be confirm power of a judicial magistrate on any member of the judicial service of a state functioning as a judge in a civil court. The High Court is also required to appoint a judicial magistrate of the first class to the chief judicial magistrate. Chief judicial magistrate of the district, full stop. The High Court is also required to appoint a judicial magistrate. The High Court is also required to appoint a judicial magistrate of the first class to the chief judicial magistrate. CJM of the district, full stop. This main function is to be guide, supervise and control other judicial magistrate, full stop. He might also trying important case. The High Court may appointed any judicial magistrate of the first class. The High Court may appoint any judicial magistrate of the first class to be in a additional CGM, and such a magistrate shall have all or any of the power of a CGM as the High Court may direct. For any subdivision of a district, the High Court may appoint any judicial magistrate of the first class as the subdivisional magistrate, who shall have power of the supervision and control over the work of the judicial magistrate in the subdivision. Judicial magistrate in subdivision, unless defined differently by the CJM. The local jurisdiction and the power of a judicial magistrate would extend throughout the district. Every CGM shall be subordinate court of the metropolitan magistrate in every metropolitan area. The state government may, after consultation with the High Court, establish court of metropolitan magistrate at such place and in such number as it thinks necessary. Full stop. The presiding officer of such court shall the jurisdiction and power of the every such magistrate shall extend throughout the metropolitan area. Throughout the metropolitan area. Throughout the metropolitan area.